others following him to 13?
It was probably a little longer than an hour. I think we got there at 1 o'clock. He didn't come on shift till 4, and he was notified just after that, so he probably didn't.
Potential family members of this victim started to arrive right around then, I believe. Is that right?
At the time, we didn't know that, but yes, family members did start arriving, and friends and neighborhood folks and everybody else.
Okay. You had no reason to believe that anybody had gone into 1356 Ben?
At that point, no, we didn't know who the victim was, so we didn't know where he lived.
At any point, were officers searching that home for blunt-type instruments at all?
After the search warrant was signed, we conducted a search of the house, yes, but I think, I don't know what, Detective Wilder talked about they were looking for blunt force. At that point, I think my memory is, and what I told people is, and our thoughts were, it was sharp force injury, so that's what we were all looking for that day.
Okay. The two of you had different ideas as to what you were looking for. Is that a fair statement, or?
I don't know if we had different ideas. I think that day, my memory is we all had the same idea, which was sharp force injuries. That's why everything that was collected that we saw that may be potential evidence was sharp force in nature. And he and I both were in the garage at some point together. We were in the house at some point together. And I'm sure, and I think he said he found it. He may have pointed it out to me, and I came and looked at it first and thought, yes, that's something of interest. So it was really a team effort, and I agree with everything that was collected that day.
Okay. Do you agree with everything that was not collected that day?
Yes.
Including the 3 bats that were later collected by you?
The 3 bats in the photograph that we've seen, that photograph was taken the day those bats were collected.
That photograph was taken the day the 3 bats that had been entered into evidence were collected?
Yes.
Did you not go back to Amanda McFarland's home, 1356 Ben, on June the 6th?
That's when that picture was taken that we've seen.
Okay. Well, this search warrant was executed on May 11th, correct?
Yes.
Okay, so those bats were actually collected sometime later.
Correct, and the main reason those bats were collected were to try to get some evidence on the animal cruelty stuff that we were told about.
Okay, that pertained to Mr. Gouker, correct?
Yes.
She signed a consent form on June 6, 2011, right? And that's how you entered and got this at?
Yes.
Okay. And CSU actually went with you, and we went through all that?
Yes, ma'am.
At that point, Mr. Gouker was a suspect in this crime.
I mean, at that point, everybody, at what date you're saying? You said at that point.
2011, I apologize.
Well, of course he was a suspect. Everybody was a suspect on June 6th.
Only 4 people, and one of them were listed as a suspect on the CSU report.
On the day that we went back on to collect those bats. Is that what you're asking?
Yes. Is that correct?
I mean, I'd say he was a suspect. Yes, that's fair.
And was specifically listed as a suspect?
Listed as a suspect where?
On the CSU report that accompanies the collection of the 3 bats on June 6, 2011.
Yeah, I don't remember what they checked on the CSU. I know they got like 100 check boxes, but I would say that's probably fair. If you said that was on there, I believe he was probably listed as a suspect, yes.
The search warrant, though, and I'm not trying to jump around, but for May 11th, it allowed police to collect a broad spectrum of evidence, right? I mean, computers, communication devices, things of that nature.
We could have collected numerous items under that search warrant, yes.
Okay. There was, in fact, a computer in the home, right?
Yes.
And did Amanda and Mr. Gouker have phones with them at the scene?
I don't remember if they had him with them that day or not specifically. I know we had spoken to Amanda a few days later, and she made us aware that the computer didn't have an internet access.
Okay. It was also within the scope of that warrant to collect anything associated with drug activity, right?
That could have been collected, yes.
Okay. And there was, in fact, evidence of that in the bedroom.
Like there was some paraphernalia that was in there, yes. We photographed it.
And the the sum total of what was collected as a result of execution of the warrant were 2 knives essentially, I'm not trying to be too general, and then swabs from Amanda and from Mr. Gallagher, right?
Yeah, the sword, the knife, a larger knife, and the bugle buckle swabs, yes.
When you were at the scene, you indicated that you know that families started to arrive, and I believe yesterday you had stated that, and I think this is almost exact, that Amanda Gallagher arrived at Liberty. You thought possibly Terry Wicker did as well, but a little bit behind them, that that wasn't very significant to you. Do you remember saying that yesterday?
I remember seeing Mr. Gallagher and Amanda coming across that far field towards the, I guess it would be the southeast side of Liberty High School, coming towards the school. And then at some point Mr. Zwicker showed up, but I don't know exactly when he got there, but I know he got there probably a little bit after they did.
And by southeast side, just to be clear, are you talking about the Kramer Avenue side?
Yes.
Liberty? All right. That's by the Goodman's house.
Yes, that was the direction they came through, an opening in the fence. It may be a sidewalk, I don't remember.
You were actually the first member of law enforcement to speak with them, right?
I have no idea if I was the first person or not.
And you do have your investigative letter from, I think you probably have several dated May 11th, but
Does it say the date? It's the May 11th letter on there?
yes.
I have about 70 letters here. Give me just a second. I know about where it's at.
And the reason that I'm asking you this is I just spoke with her briefly and got very general description of the person.
Yes, and I do remember I do remember telling her that we didn't know if this was her son, in fact, and if it was not her son, we would take a missing persons report for her son.
At some point, shortly thereafter, I guess we agree on that Terry Zwicker arrived, right?
Some point after that, yes, he did arrive.
All right. The three of them were not necessarily together as they stood around trying to figure out what was going on.
They were not together. Not necessarily they were not together.
I'm sorry, I missed
They
that.
were not together.
At some point during this time, before any identification of the body, there was some discussion amongst everybody out there about who did this, right?
Well, of course we're going to talk about who we thought did it, but I don't know if there was any specific names mentioned. We're just all trying to run scenarios through our own minds.
Okay. You're trying to gather information quickly, but your primary concern was confirming who that was down there, right?
Correct.
At some point, and I'll ask you, how long was it before a decision was made to allow Terry Zwicker just to try and identify whether or not that was right?
I started interviewing Mr. Zwicker at about 4:47 p.m., so it was probably 20 to 30 minutes before that. Or maybe actually it was at 4:35 is when I have that Lieutenant Wilkerson and I made the decision. Of course, he's my lieutenant, so he made the final decision to let Mr. Zwicker view the body from above the creek. That would save hours of time trying to identify the victim.
You had already attempted to get prints from the body, and correct? I mean, that
Yes, and then I think Mr. Zwicker told us that Trey did not have any prints on file. So at that point, it's just so much easier for him just to say yes or no. At typical crime scenes, it happens quite often, so where anybody can see the victim, including family members. So a lot of times it saves us hours of work.
And it was confirmed that he didn't carry an ID on him, so there wasn't a way to tell who he was.
I think there was talk that he may have had some kind of school ID on his lanyard, but I don't know if it actually had a picture of him or not, or a name. It was just related to his school.
Immediately after Terry Zwicker identified his son, that's when he got in your car. This is 4:47 is the time, right?
Yeah. I'm sure I gave him, I'm sure it was a minute or two, he composed himself, and then we got in my car and I did an interview, yes.
And you do, and I'm not being sarcastic because I know I say this verbatim because I've listened to a number of interviews that you've done, but you do start all your interviews the same way, right?
I try. I may forget sometimes to say something, but so I try to give the dates, times, and who I'm with, and things like that.
Date, time, who you're talking to, right?
Yes.
You try to get full name, legal name, right?
Yes.
Date of birth sometimes. Is that, you usually ask for people's date of birth?
Usually, I mean, I have forgotten a few times.
And then at least a phone number.
If they have one available, yes.
Okay. And an address.
Yes.
Nothing different about that either, with Mr. Zwicker, that is. Is that right?
Correct. Doesn't appear to be anything different. He gave me his name, address, date of birth, home phone number, cell phone number.
And of course, you cover the generalities of what living arrangements are in his home, his son, what his living arrangements were, right?
I don't remember the specifics of the living arrangements in his home. If there's a specific thing you'd like me to look at, I'm sure I covered that at his house, but I don't remember the specific conversation about the living arrangement at his house.
Generally, as the beginning of any interview, who lives with you, that kind of thing, you covered that with him.
Yes.
At that point, you got a little more specific, but it's clear that you had an awareness that people were talking about the kids from Bridgewood already, right?
That came up, yes. I'd ask him about that, if he knew about the problems in the neighborhood with cell phone and things like that.
And we agree as well that Mr. Zwicker is a little bit removed from everything going on film because he doesn't live there. It's just a practical thing.
I don't know if I would agree. I think he didn't live there, but he knew what was going on, and he had eyes looking out for him and would tell him things, so I think he was pretty well aware of what was going on.
And I believe in that same letter that you have in front of you, if you refresh your recollection. Detective Maroney, nearly simultaneously with the beginning of your interview with Mr. Zwicker, began interviewing a number of people in a different location.
I mean, I don't know the times that Detective Maroney started interviewing off. I mean, I can look through these letters, but I don't know the exact time she started interviewing. I was busy doing my interview, so I don't know.
Okay. You recall her testifying to the time she began the first one?
I don't remember the time she said.
You recall the order in which she interviewed people that day?
I don't remember the order, no.
Would it be fair to say that she was speaking with people around the time you were speaking with Mr. Zwicker?
Yes, I know she was speaking to neighborhood kids, Amanda, the defendant, Mr. Gowker. What order they were in or who she spoke to first, I don't remember.
You spoke with Mr. Gowker that day, too.
Yes.
And it was sometime after everything was initiated, any notification about the body being there, right?
Yeah, I mean, I spoke to him at Liberty High School in my car, yes, and it was at about 6 o'clock at night.
It was about an hour and a half after Terry Zwicker had identified the son, right?
That's about almost correct.
And that interview didn't begin in the routine way that you usually start them, right?
I just have a letter written the same way, whether or not he gave me all the correct that information. I have that he provided the address, date of birth, cell phone number, and Amanda's cell phone number.
Okay. It doesn't begin in the normal way that you usually start an interview, right?
I'm not sure what you're asking.
It begins with you explaining that he can't see the body.
I believe that may have come up after. At some point, I got his information. I'm not sure what you're asking. I don't know. I don't remember the exact wordage was used in the audio recording of it.
Just 1 second.
I don't know if I got his identifiers before, but yes, he started out by saying he wanted to see the body.
Okay. Do you have the transcript up there with you?
I've got it.
If you could just skim the first third of that first page.
It looks like he immediately got in my car and immediately started saying, or I was telling him that he can't look right now. I can't do it. It'll be let the coroner make that decision. And he asked who I was, or asked me if I was Russ.
Okay, so you had just met him.
Yeah. I just started the interview. I think we mentioned earlier that I saw him or spoke to him briefly earlier.
he was with Amanda when you first spoke with her a lot earlier that afternoon.
I think he was standing by, yes.
How long had you been speaking with him before that came on? I know
I think that it was actually already, I had it recording in my car before we got in. So as soon as we're getting in, you hear me say, I can't let you see that right now because it was already recording.
It was already, do you just leave it on because you know you're going to go and get someone and ask them?
In this situation, yes, yes.
Okay. You indicated yesterday that you weren't sure that he'd already been interviewed, and that was why you interviewed him again, or for the first time you thought, or?
No, I think I testified that I just wanted to do a follow-up interview with him because at that point we knew who the victim was, who he lived with, and I wanted to do that interview, an additional follow-up interview myself.
But he was the only one who was interviewed officially on tape 2 times by a homicide detective that day, right?
Yes.
There were good reasons that someone would want to do that as the lead, right? You saw injuries on Amanda, right?
Yes, I saw bruises on her neck, yes.
And it wasn't the first, he didn't just ask one time about seeing the body, right?
No, he asked several times.
And eventually you let him do that.
Yes.
That's not good policy.
It's no different than if Trey would have been laying in the middle of Indian Trail, he would have been able to see the body. So we conferred. I talked to my lieutenant and sergeant. We decided to let Mr. Gowker see the body.
You couldn't see it from where the crime scene was boarded off, right?
No.
No one could.
Right.
You had to stay back
Correct.
and protect the investigation.
And he walked up to the same place that Mr. Zwicker did, which is the top of the fence, the top above the school.
He had to be escorted by you, right?
Yes.
And, you testified yesterday, obviously, you had some leads leaving Liberty that day, right?
As far as Bridgewood, yes.
In terms of, you speak with everybody involved in the investigation because you are the lead, and you were hearing about that from several different people, right?
Yes, and in fact, while we were there, somebody said that there was a group of people, white people, chasing one of the black kids over a few blocks away, and we had to send patrol cars over, but I don't know whatever came out of that.
Were there any black people at Liberty just that came up because they heard about this, or?
I don't remember if there were or not.
And again, I'm not trying to jump around, but I know that you do have everything from your investigation up there with you, and I just want to confirm some phone numbers with you.
Okay.
And I don't know if you might need a minute to pull something, but we know Mr. Gowker's cell phone number, what that was, right?
502-356-5617.
So I'm very familiar with that number. I know that it's. What about Amanda?
I believe the number I was given for Amanda. All right. 712-7514.
Trey's with her?
I've got them somewhere.
I will tell you that it's probably in your May 11th initial memo because
don't see it in the May 11th initial letter.
His father confirmed what his cell phone number is, right?
Let's look. You have the page. I don't see where it's at on here. I see another young lady's phone number. Or if you just want to show me.
And Afro's the one that's got
Yes.
You have his phone records up there, correct?
I don't know if I brought the phone records up. They may be in
You have those, all of those? Now, may I approach the witness?
Standing permission to approach the witness.
Looks like it's 295-3521. Sorry about that.
What about, and this one won't be in that same bunch of information, Angelique's number? While you're looking for that, and I'm not trying to make you go through every bit of that, we can come back to that, and I will refresh your recollection, and I'll probably document for that as well. The 356 number, again, that was Joshua Gowker's cell phone number, right?
Yes.
Okay. Fast forwarding for just a second into, a year beyond all of this beginning, you learned that Cassie Gowker had that phone.
Yes.
And you learned that because you, trying to follow up and be thorough, got a series of jail phone calls trying to find out who he was communicating with,
I got jail phone calls from several different places, yes.
including Alabama, right?
Yes, yes.
Did you get calls from both facilities in Alabama or just the one from Birmingham? Madison, I suppose.
Madison, yeah, I believe it was just Madison.
There was communication to that number from that facility, right?
To 356-5617. There was a lot of phone numbers. I believe he called Cassie from Alabama on that phone. Yes, she had that phone.
And we heard a portion of one of those calls during this trial, right?
Yes.
Also, Hopkins County Jail in Kentucky, right?
Yes.
Wood County Jail in Indiana.
Yes.
And Hopkins County Jail, there was communication to that number, right?
I don't remember specifically.
What about Wood County?
Again, I don't remember specifically if that was the numbers that was called. I probably listened to 200 hours of jail phone calls.
That is more than fair in terms of estimation. Judge, may we approach?
Yes.
standard software that you see on just any computer, right?
Right.
It's when you get calls from a facility, they're going to be in a special format, special software.
Yes.
Okay. And, sorry. This listing, can you read just one of the dates on here? Can you tell what date that is?
Looks like 11/9 of.
Okay. It's not really formatted that way, but you learn to decode these things if you keep listening to jail calls, I imagine, right?
I don't know.
Well, it's just not written in the standard order that people usually put a date down, is all I'm saying. But you knew what date that was.
It's right there, yes.
Okay. As to the line that I just showed you, can you just note what phone number that call was made to?
502-356-5617.
Okay. And I'm not going to sit here and ask you to count every single time that number is called, but you'd agree repeatedly.
Yes.
Just lots of phone calls to that number.
Several phone calls that number,
Okay.
yes.
And I know that you indicated that you have reviewed all of those calls, right?
It's been a while, but I've listened to lots of jail phone calls.
Probably on more cases than this one, I would imagine.
Yes.
So you are aware as well then that there was communication to Angelique, right?
I remember them speaking, yes.
From one of the facilities. I'm not trying to confuse you.
Yeah, there was three
Okay.
jail facilities I listened to calls from, so.
Along with other people from Mr. Gowker.
Yes.
At any time when you were reviewing the calls, were you made aware of Cassie's work phone number?
At some point we were, because I remember calling that phone number of hers the morning we came back from Alabama. I believe I called her on that number.
And that was when you were trying to connect with her and see where it was that she claimed that she drove Joshua Young around to drop off evidence, right?
That and to follow up just with some of the answers she gave on the previous phone call that night.
But you called that number to reach her?
At some point I've called her on that number.
Okay.
She was not supposed to take calls on that phone number because I think she would get in trouble from her employer, but at some point I know I tried it once or twice or a few times.
And in several of these facilities, if not all of them, there's communication made from Mr. Gowker's ID number to that number for Cassie, right?
Her work number?
Yes.
I don't remember what her work phone number is, but I would just have to assume, but I'm not going to do that. I don't know what her work phone number is. I don't have it in front of me.
Okay.
I remember a conversation they had where she said she would get in trouble for using that phone on one of the jail phone calls, so yes, she was called on that phone number.
Primarily, though, it was to that 356 number, right?
Yes.
And just to be clear, the span of time, the latest date for which jail calls were obtained in this case go to about early 2012.
I have no idea what the last dates were that we got. I know they were from Floyd County, Indiana.
Okay, that would have been summer 2012, right?
I don't know the dates.
Well, you remember that Mr. Gowker got indicted August 2012, right?
Yes.
Okay. And he was in Floyd County as of when he was indicted, right?
So mid-June, July, that sounds about right.
And just to summarize, at 3 different facilities, there was communication. I'm not trying to generalize too much. There were a lot of calls to that 356 number from each facility.
I remember that being calls. The total number of calls, I have no idea.
There were at least some to Cassie's work number, right?
Yes.
And there were at least some to Angelique.
Angelique, yes.
Now, as far as phones go, early on, Trey's phone was taken as evidence, right?
Yes.
When you saw that, it was admitted as evidence. What is a forensic on a cell phone?
The forensic on the cell phone is where someone would take it out to the FBI's regional crime lab off Blankenbaker, Sometimes they would assist in helping. Most of the time, there's a self-service kiosk that's set up out there, and all the information is just downloaded from the phone from a little kiosk.
There's a kiosk at the forensic center.
Yeah, it's basically self-service. If not, you would wait. They have thousands of phones. You'd probably wait years to get stuff back.
So it's more or less USB connection, and it just takes all the data off of that, right?
Yes, I've tried to use it once, but usually other people take phones out there during the day. Since I worked 4 to midnight, it was closed, so the day work folks would usually do that.
Okay. Well, I mean, a forensic was actually performed on Trey's phone, right?
Yes.
Okay. And phone records were obtained for his phone.
Yes.
Okay. Phone records were obtained for Amanda's phone for 2 or 3 day window. Is that right?
Yes.
Phone records were not obtained at that time or an attempt made for Mr. Gallagher's phone.
Correct.
And I believe you've already stated that sometime later you tried to get those and they were erased, or could you explain what happened when you attempted to get those?
The company said they no longer had those records. I guess I don't know, they destroy them after a certain amount of time, or they just didn't have the records. I don't know what exactly they said.
Okay. And that request was made roughly a year after the crime, right?
Yes.
At a time when you were aware that communication was being made to that phone from various facilities, 3 different facilities?
Is that a question?
Yes.
Could you repeat the question?
You had attempted to obtain the phone records for the 356 number well after you were made aware that Mr. Gallagher was calling that 356 number.
Yes.
As of July 2012, you did attempt to get that phone back from Cassie, right?
Yes.
Okay. And got a search warrant,
Yes.
although she was cooperating with you.
She was.
You collected one phone. What happened with the first phone? Got it for a reason. Were you going to have a forensic done on that one?
The first phone, I'm not sure what you're asking.
You ended up actually having to go back and get a different phone from her, right? In July 2012?
I remember at some point getting the 356-5617 phone. I don't remember I don't remember specifically what phone you're talking about.
It was July the 13th, 2012, I believe, that you got a search warrant to collect what you believe to be Joshua Gallagher's phone in her possession, right?
Yes.
That's how the warrant was written.
Correct.
Okay. So you went to her home, right?
Yes.
And you got a phone.
Yes.
What happened from there with that phone?
It would not power up.
That phone would have been the second phone you got from her. Isn't that right?
I just don't remember off the top of my head getting 2 phones from them.
You don't remember having her sign a consent form the second time you went there to ask her for a phone?
Vaguely sounds familiar, but unfortunately I don't have all 1,200 pages memorized. I just can't remember going back for a second phone off the top of my head.
Do you remember attempting to do some kind of a forensic on not one but 2 phones that should have belonged to that number?
I remember trying to do the one that the phone would not power up.
Okay. Was this at the kiosk at the forensic, at the FBI office, or?
Yes.
And the FBI, would they have been able to assist you in getting data off the phone? I know that it's kind of a self-service.
Yeah, the phone would not take a charge, would not power up, so it was not possible to get any data off of that phone.
Would you consider trying to get another battery for the phone?
I don't know if we put another battery in the phone or not. I think I had somebody that had a phone that was similar to that or something. We tried that, and the phone would just not power up. It would not it just wouldn't come on.
Somebody else let you put theirs in the phone? Is that?
I remember us trying to get another battery for it. Who gave me that or whatever, I don't remember, but the phone just would not power up. And even I believe when Cassie gave me the phone, she said it was broken, wouldn't work.
Okay.
But we tried.
That would explain why you went back and got a different phone from him, right?
I don't remember going back to You want to help me with a letter or something? I don't remember going back for some reason to get a second phone.
Do you have the search warrant in front of you? Or I have it if you would like to see that.
Yeah, that'd be fine.
Now, we agreed that, we agreed on that. That's what you did. You went and got a warrant, right?
Yes.
Did you just indicate what the date on the affidavit is?
Looks like July 13th, 2012. It was signed by the judge.
And I'm not asking you to read aloud anything, but have you reviewed the other document I just handed you?
I can't tell by looking at this if these were two separate phones or the same phone.
Okay. But definitely two instances of permission or a court order to obtain phones pertaining to Joshua Gowker from Cassie Gowker.
Yes.
On two different dates.
Looks like two different dates, yes.
Within about a week's time.
Yes. I don't know if they were, I just can't tell if these were two specific phones or if I got the phone by this phone from her and then just decided to write a warrant on it. I can't tell by looking at these are two separate phones, and for some reason I only remember one phone.
I missed the second part of your answer in terms you can't tell if it was two separate phones because, or if it was something else, and I missed that.
Yeah, the consent she signed has a model number, and the search warrant doesn't have that same model number, but it has the same, it's the phone number. So I just don't remember collecting two phones. I remember getting one phone from her that did not power up, and that's all I remember right now.
You didn't have information specific to the model number when you put the affidavit, right?
That appears right. But both of these say Cricket phone, so I'm just believing they're the same phone. I don't remember collecting two phones.
That you needed to get her consent despite the fact you had a search warrant to obtain a phone belonging or associated with that number that she had in her possession.
There is a search warrant here, and there is a consent to search. I remember only collecting one phone right now. I only remember getting one phone from her.
And a forensic could not be done on the one that you recall collecting, right?
It would not power up. It would not do anything.
If there had been two phones, we don't have any evidence, we got any information on either of them.
Correct.
As to phones, when it came to the investigation involving kids that, we keep calling them the Bridgewood kids, but the kids that were cleared in the end, right? That was done with phone data, was it not?
Clearing them?
Essentially.
With the phone data of I believe the initials of one of them, I think it was AD. I reviewed his phone records, yes.
And you obtained ping data.
Yes.
And you described what that was for ignorant yesterday. If you just briefly.
That just shows the closest tower that they would be next to or near that the phone was hitting off of at the time.
And the ping data associated with AD showed he was nowhere near where this happened, right?
Correct.
Did you get ping data on Trey Wicker's phone?
I don't remember if we got ping data on his phone because he lives so close to where the murder occurred. I would assume if he had used his phone, it would have hit off close to where he was at.
And you'd indicated that yesterday with regard to, I believe, Amanda's phone, right?
Yes.
Or Mr. Gowker's or both, right?
I believe both. We did not get ping data off either of the phones.
We learned, because of the trip to Alabama, about 6 weeks later, roughly, that somehow Cassie Gallagher had involvement in this, right?
At the Alabama, yes.
And that she drove somewhere
Yes.
far enough away that her ping data would have indicated to you that that could be corroborated.
If she would have used her phone or even had her phone with her.
Ask?
I don't know specifically remember asking if she had her phone with her. And it was like 4 miles away, so I'm not sure if it was probably just, I don't have the information, so I can't speculate on if she did or didn't or would or would not have.
It's fair to say ping data, part of the investigation of this murder, was collected for one phone, right?
It may have been collected for a couple of the Bridgewood kids, but I only reviewed the one from, I think it was AD.
It would be in discovery.
It would be, yes.
You agree there's one set of ping data in there.
There's a lot of phone records. I remember reviewing AD's ping data. That's all I remember looking at.
Again, your investigation into those potential suspects was thorough. There's no doubt about that, right?
We tried to interview 6 of the kids, some of their families, foster parents, some, and the phone.
I'm sorry, I
Oh, just and the phone pings on the AD.
police reports were obtained, right?
Some reports were obtained for some of their activity for that time frame, yes.
There was some stuff that you thought might match up with what happened to Trace Woodruff, right? You wanted to make sure, for example, that somebody wasn't incarcerated because that could be stuff like that, right?
Yes, and I knew I was going to try to speak to each one of them so I would get their story of where they possibly were that night. Or if they had prior problems on Vim Drive, I was going to ask them directly.
Okay. When you obtained the police reports that we do have, did you find any incidents at all over there involving anybody?
I don't know if I specifically looked for the ones around Vim Drive because I knew I was going to ask them directly, but I know we pulled reports from other incidences they were supposedly involved in that night or the night before.
Did you do a search, not specific to the kids that you were talking to and trying to find out what happened with them, but specific to that street or that area?
I don't remember looking at any reports about incidences on that street.
You heard about some, and that was why you were even talking to these kids, right?
Yes. And there's more to it just than just that. We were also given information that, I guess the initials, it was, I'm trying to think of all the initials of actually it was 7 kids we interviewed. DH had made somebody aware that he had information on AD. I'm sorry.
That's okay. Didn't mean to.
So we spoke to 7 kids, yes. It was more than just the rumors from the neighborhood.
Right. You had a basis to talk to them.
Yes.
My question is, the rumors in the neighborhood led you to believe that there had been trouble on the street, right?
Yes.
And so you started to look in that direction, obviously.
Yes.
Did you do a search for any calls to the police from that area leading up to this murder?
No. I did not, or if it was done, I don't know. I did not.
You are the lead detective, right?
Yes, but I was going to talk to the kids involved directly, so I was going to ask them directly.
If someone had looked into that for you, you would know it, because you're the lead detective.
Yes, I would.
As far as, I suppose, the infamous video that we keep hearing about but we haven't seen, to your knowledge, does that exist?
I mean, I can only tell you that he had during one of the interviews, Mr. Geiger had his cell phone with him in the interview room at the homicide office, I believe was on the 19th, or the 14th, on the 14th. And he had it turned towards me and Detective Stalvey and was, really wanting us to watch this video. So I would assume if we'd have said yes, he would have just hit play. Now, we did not see it. I can't say the video 100% exists, but it seems he was ready to show us hit play and we were going to watch it. We did not watch it at the time. It didn't seem relevant, nor appropriate to sit there and watch that.
It sounded pretty gross, the way he described it. Is that a fair statement?
Yes.
Okay. You kind of shrunk back from it, like, no, this is inappropriate, and just kind of moved on, right?
Yes. Correct.
Or Amanda's, early on?
We got our phone records, yes.
Okay. You also obtained her SIM card at some point, is that right?
Yes.
And that would have been summer 2012? Is that?
That sounds about right, yes.
And why did you do that?
I think that was just in relation to she had brought it to the Commonwealth attention that she had the SIM card, and they'd asked me to come retrieve it from her.
And was a forensic done on this? Can you do a forensic on just the SIM card? I suppose you could pop into the device of some kind.
Yeah, the kiosk allows that, yes.
Okay. Did you do one of those on the SIM card?
There was things pulled off of it, yes.
Okay. Was there any kind of a pornographic video on there between herself and Mr. Gowker?
No.
It's not as though, and we know at this point that there was an assertion by Mr. Gowker that this involved a banana, right?
Correct, but there was also a confirmation that Amanda said the video had been taken, but I think left that part out.
On her phone?
On her phone, yes.
There was some corroboration that it occurred because there was a banana peel in the bedroom wastebasket, right?
There was, yes.
And that's a picture admitted into evidence, right?
Yes.
Was that collected?
No, there was absolutely no reason to collect it. And when that photograph was taken, we did not have that information. That was obtained a couple days later.
As compared to white grape wrappers, you saw both at the spot where the body was.
Yes.
Right? And then you also saw one in the wastebasket.
Correct. But the one at the house, there was no reason to collect because we assumed it belonged to them and would have their DNA or it was in their house and their trash can, so there was no reason for us to collect it, but we photographed it.
There are serial numbers on wrappers like that, right?
Yes.
Could have compared those with what was located down there at the spot.
Probably could have, yes. But he had told us in his interview that, and she said they were down there 2 days before smoking those cigarettes, or smoking the white grape.
She told you that 3 days after the body was found, right?
Yes.
And she said something about it in that 8 days after the body was found.
Yes.
Essentially, the investigation into the kids we've been talking about so much, it's just, you realize this wasn't these kids, right? Essentially.
After the Alabama interviews, those kids were put on the back burner, yes.
So in your mind, they were not conclusively ruled out?
I'm not going to at that point, I'm not going to conclusively rule anybody out, but when we came back on, I guess it was June 21st, I believe, or 22nd, when the arrest was made, I was confident then at that point they were not involved.
Okay. Because you had been handed someone else?
Information was obtained on someone else, yes.
Let's be clear that on the date that you asked Amanda to consent to a second search of her house and you got the bags, that was right before you got the phone call into Alabama, right?
The second search at Alabama, I'm not sure what you're talking, going back to collect the bats on the...
Yes, it's just timing in terms of...
I don't remember the exact day we went back over. It was the 20... I don't remember the date we went back over to get the bats. I think it was... If you have it in front of you, you can tell me. I'm sure it will come back to my memory pretty quick.
Earlier, I thought that you had gone back over there June the 6th and collected those with her permission.
June 6th sounds correct, yes.
And 2011, just to be
Yes.
You became aware during this time as well that an EPO was issued against Mr. Gowker, right?
At some point I was made aware of that, yes.
By her, by Amanda.
Amanda told me, and I think it was even on TV, I don't remember, but I remember EPO was issued.
And I know that there has been testimony regarding an Amber Alert.
Yes. I was not.
You kind of alluded to that, but you were aware that one was issued.
I knew that a family court judge had requested that through the Kentucky State Police, and the Kentucky State Police are the ones who are responsible for the Amber Alert, so I was made aware of that. And then either a day later or the next day, it may have even been the same day the Amber Alert was issued, Mr. Gowker, I believe his uncle, called me and said he was in custody in Alabama. And that's how we all knew where everybody was at.
Mr. Gowker called you.
At some point he called my phone, but the original way I found out that information was, I believe, from his uncle.
Okay. He called your phone, meaning what, your office phone? Or?
Yes.
He called you several times, didn't he?
He called a lot of times where they were just messages left, yes. And I spoke to him a couple of times.
He was calling you way before any Alabama, far early in the event. He had close contact with you. Is that a fair statement?
Yes.
But he also called several times upon being taken into custody in Alabama.
There were some messages left, yes. And I may even have answered once or twice. There were so many phone calls, I can't remember exactly how many.
Well, you did talk to him because that's why you went down there, right?
That phone call was made from Detective Adams. He'd asked me to call him back, so I called Detective Adams back. And then he told me Mr. Gowker wanted to speak to me and had information for me, and that phone call was recorded. And then that's what led to the drive down to Alabama.
And I believe you even testified that you had him elaborate just a little bit because you didn't want to, that's a long drive, right?
At 5 or 6 hours, yeah.
You jumped in the car just right then and there, correct?
Yes.
And you had to get permission from someone above you and Salvi went with you, right?
Correct. My lieutenant had to approve it, and then the major was on vacation, so the acting captain had to approve that.
And the additional information which you asked him to give you in order to show that you weren't going to be wasting your time was he could solve your case, right?
Yes.
And you made him specify what he meant by that.
Yes.
And he said Trey, right?
Talking about the murder, yes.
Okay. And then essentially named Joshua Young as the person who did this. Right?
As the person who he was going to give me information on.
And you left town how long after that call?
It was probably within 2 hours, I'm not sure.
And you talked to him for hours down there, right?
Yes.
You talked to him for a really long time before anybody's name came up here in Louisville, right?
You're talking about, we talked on tape for the whole conversation, and we stepped off at one point. There was a few-minute break when we called the Commonwealth Attorney, but yeah, it was probably 4 hours plus.
Well, you also had to go off the tape because you had to get a phone. You weren't in a room that had a phone where you had a signal or something
Right.
like that, right?
So we went to a different room. There was no way to get phone access into the interview rooms they had in Alabama.
And I believe yesterday, let's just be clear, just from the beginning, you heard a lengthy recitation of what Mr. Gowker claims Joshua Young told him, right?
Yes.
And that did not involve anybody else. It was simply, well, one version, right?
For most of the time, yes, until we took the mid-break, and he said, can we go off tape? I have something else I want to tell you. Of course, I don't like going off tape, but I want the information, so I listened.
Well, the video camera was still rolling, right?
Yeah, because I had my little digital recorder in there, and then they had their, but I can't remember if we stepped out when he told me that or if we were still in the room.
Essentially, he didn't want to name any names until he confirmed that that person wouldn't get in trouble, right?
Correct.
And eventually, that was arranged, right? That's
Yes.
what you're talking about, calling and talking right on the...
Yes.
And who is that? You may well have said just now, but...
I mean, she's the assistant Commonwealth attorney. She was the second point of contact for the homicide. She was their second point of contact liaison from the Commonwealth to the homicide unit at the time.
Okay. Mr. Gowker got her complete immunity before you even called Cassie, as you were talking about, right?
But we had an idea of what he was going to tell us, which was she only drove the defendant to this dumpster. That was kind of the basis of it, and there was no more involvement with her in that. But we did not maybe not to the dumpster, but she had information about where I guess the things were taken, the items were taken, something to that effect. So we wanted that information. We didn't know where she was going to say they were at. So yes, I asked the Commonwealth if that would be something they would do, and they agreed, and we got the information.
He had super slim, slight involvement.
That was my words, yes.
Okay.
That's what I was telling her after we got that after we already got the Commonwealth to agree. That, I believe, is what I told her on the phone.
Right, right. That second recording, no doubt about it, begins with, I talked to Ryan Conroy, right?
Yes.
Okay. And from there, we know what happened. And several people were contacted. We've heard that each of whom, in one way or another, claims that Joshua Young told them he committed this crime, right?
Each of the ones we called said he admitted to the crime, yes.
You have been the lead detective on this case from the beginning, right?
Yes.
And Joshua Young, after you came back from Alabama, you've already testified to this. You came back, tried to get a hold of Cassie, talked to her on the phone briefly, right?
That morning, yes.
Trying to make contact to have her show you where she went that night, correct?
And just to solidify what she told us, because obviously everybody's heard that what she originally said. She was unsure, uncertain of her answer, and then she told me the story about Josh Young and her involvement. So I wanted to go back and speak to her specifically without Josh Gowker's presence, knowing he was on the phone, away from him, and to make sure what she's telling me is the truth.
As many times as he told her to tell the truth, does that mean, do you think that might be effective with her?
I can, just from past cases, there are people that will not talk to the police unless somebody says it's okay to talk to the police. So we wanted the information from all these people, and if it had to take for Mr. Gowker to get on the phone to say, you can tell them what you know, that's what we did.
Clearly somebody that wouldn't talk to you if they needed his permission was intimidated by you.
I don't know if they were intimidated by him or not. I mean, I think that sounds probably fair, or they would just give us the information anyway. We have spoken to them several times. Nobody gave us that information, so we wanted the information. If he had to tell them it was okay, and I mean, it seems reasonable that if you're going to tell on Josh Gowker's son, Josh Gowker's going to have to Yes.
You saw an investigative letter and it remember what?
Yes.
I'm sure any April 4th investigative letter.
Okay, yes.
Does that refresh your recollection?
Yes, that's when I was trying to serve her a subpoena and ask her if she had any additional information.
And did she?
Yeah, that's when she said that Gallagher had appeared one time.
Going back to the beginning of the investigation, when you said that you didn't walk through the water towards Van Drive,
Correct.
did you walk on land towards Van Drive?
I did, and along with the K-9 unit that checked the area for any.
So that entire area was searched?
Yes.
When you took Mr. Zwicker and Mr. Gallagher to see Trey's body, where did you have them stand?
They were above the creek on Liberty High School's property, close to the building. It's a few feet away from the building, there's a fence.
So were they standing on concrete?
I don't know if it was concrete or grass right there. There might have been a sidewalk. I think it's grass, but I can't remember for certain.
But is it the area where cars can drive through?
I mean, it's not meant for cars, but I think cars can drive through there, yes. It drives over that tunnel. You're on top of the tunnel that goes underneath the school.
I can't find the right photos. I don't want to waste a lot of time, but just looking at the map, would it be that area right there by the school?
Yes.
Okay.
All right, it's gonna take me a minute.
We're looking for the laser pointer.
I've got it.
It seems to shut down after a while. I don't know why it does that. It takes a while to warm up.
Right about, here's where I was parked. There's this sidewalk right here. This is the school. Right? I don't know if this X was marked where Trey was down below or if that X was put there for some other reason, but right in this area by the school, there is a fence that goes atop of the tunnel that would go under the school. And he was above the crime scene and probably looked down. It was probably about 20 feet, 25 feet outward, and about probably 10 feet down, 9 feet down. That's about the height of that tunnel.
So can you walk from down that little sidewalk that you see all the way around?
Yeah, you can do that. Yeah,
Is there a fence
right in here.
far side of that sidewalk?
Right. Yes.
And does that overlook the creek?
Yes.
Can you describe, while this is up here, how, what is under the trees on each side?
Well, you can see the creek runs, ditch, creek, whatever, runs through here. So that's what's going under there. And there's the tunnel that goes under the school and comes back out on the other side.
How high is the land on either side of the ditch?
I mean, it probably varied in several places. Like the tunnel was about probably 8 to 10 feet tall. So the tunnel that you go into is pretty high. It was much taller than me. And then the land that goes up on each side, it varied in places. It was probably, 6 to 8 feet in each direction, maybe a little bit, maybe give or take.
Where the train was found, was there a bit of flat land
Yeah, you would walk down to where he was at, and then it kind of flattened off just for a few feet.
Can you show with the laser pointer where the crime scene was blocked off with the tape?
I know we had crime scene tape on both sides here, and at some point I know we had an officer just down here. I'm not sure if he left after the K-9 unit did their search, because obviously I was interviewing other people.
Where were the family members standing?
Most of them were kind of corralled in this area over here, and a few people I think had showed up over here into the parking lot.
There was testimony about potentially two phones retrieved from Cassie. If I showed you investigative letters from this summer, would that be involved?
Yes. Okay. Yes, I remember now. Yeah, the first phone on July 13th that we had obtained was supposedly for the 502-356-5617, which was Josh Gowker's number. But John Robertson had told us that was not the same phone, but the same phone number. And then I was made aware that Cassie said she actually still had that phone that was broken for the same number that happened for when the murder occurred. So there were two separate phones.
Did you analyze both phones? Or attempt to analyze both phones?
I know the one that would not power back up was taken out to the RCFL, but I just can't remember.
Once you found out it was the different phone, but it just had the same phone number, would it have had anything evidentiary value to you?
It would not when I found that out, but whether or not that information was true at the time. But since he told me that, and she still had the separate phone, I don't think I did anything with the first phone that he said was the same number, but was obtained after the murder had occurred.
When did Gowker go into custody?
Which time?
To,
After his indictment?
no, prior to that. When did his custody start, as far as your investigation? Did he go into custody in June of 2011?
No. June of, I'm trying to think what you're talking about.
On June 20-something, 2011, was he in custody in Alabama?
Yes.
Where was his phone then?
I believe Cassie had it.
And from that point on, except for the brief period where he was mistakenly released out of Alabama, did he remain in custody with one state or another?
Yes.
And during that whole time, his
With Cassie.
Okay. Did you listen, did you order and listen to every jail call?
Oh, yes.
And did you provide them your discovery?
Yes.
On a jail call, can you hear everything that's said?
Not always, no. It just depends on some jails have better phone systems. Some are not connected well. Sometimes they could have the phone away from their mouth, so not every word can be heard, not all the time, no.
But did you listen to all the reads?
Yes.
Did you text from jail?
No. Not from their jail recorded phones. If they sneak one in, that's possible, but but not from these calls, no.
Do you have any reason to think that there were texts coming from jail?
No.
If you got phone records from the phone company, would it provide you with a recording or a transcript of a conversation?
No.
Until you were aware that Cassie had Gowker's cell phone, did you know Cassie to have a cell phone?
Her work phone.
When you
Yes,
Did you feel that they had any evidentiary value?
I did not. I mean, for one, the white poles were a hollowed aluminum, basically like a tent pole, which I have some myself. If you would have hit somebody with that force, those would have been bent or damaged in some way. I remember looking at really the vast majority of the stuff that was in that garage was, you could tell, was dirt covered, not moved. Spider webs were covering a lot of it. So that's why it felt there was no really evidentiary value.
I believe there was a question earlier about the Bridgewood pins being ruled out by the Alabama information. Was that the only reason they were ruled out?
That, the phone records, some of their family had told us where they were at that night.
Is there a surveillance video on one
At the Speedway on Bardstown and Grinstead.
I believe you were asked why the only pin data was on one of the Bridgewood children. Why was there no pin data gathered on the Fifth Drive crowd?
Because they all lived within probably 200, 300 feet of the murder scene. So I figured if they were using their phone between the 200 and 300 feet, it would ping anyway, even if they were, at home on their couch.
Recross.
You just refreshed your recollection about the two phones, 2356 number.
Yep.
We've established that phone number is the phone number Mr. Gowker gave you on numerous occasions, right?
Yes,
That Cassie Gowker had that.
yes.
And she had it as of when Mr. Gowker left Alabama. At that point, she's had that ever since, or she had that phone.
Prior to him leaving, it appears, yes.
And I'm just trying to clarify, which of the two phones is it your understanding would have been in use and active to that number when this murder happened? The first phone or the second?
Probably the second one from what I was told. The one that would not power up.
The one that wouldn't power up would have been the one that was in service, correct?
Back then, yes.
Right. When you're at the scene down there at the spot, okay, and you're standing in the place where Trey's body was found, because you've been there several times, right?
Before, I mean,
At any point, you're
I've been
very
there. I've been there.
familiar with the area,
Yeah, I've been there a few times.
right?
Yes.
As you stand there, you can see trails around the spot.
I mean, I don't know if they're trails. There's some openings through some of the brush. Yes.
Okay. Running north
Yes.
towards Them Drive.
There's openings, and they're not all completely open trails that I remember. There were a lot of stuff hung over in brush and things of that nature.
Clearly, there are worn paths going in different directions from that location.
Yeah, but I remember one of the worn paths that you're kind of referring to that goes towards Vim Drive. At some point, it kind of stops at the water where it's deep, so you would have to really be up on top.
It cuts up to the top of this bank, right?
Right.
And then you just walk right along the ditch.
You can do that, yes.
And it's mowed.
Somebody mows that lawn, yes.
As far as jail calls go, inmates use each other's PIN number all the time to make calls, don't they?
I'm sure it happens, yes. I've heard that.
That's a way to avoid detection.
Well, some people may not have money on their books, so they're using other inmates' just money.
Right. Not always for deceptive purposes, but people are not always recorded when they make calls in their own name, right?
I mean, that's probably a fair statement. Because I even think some of these phone calls I listened to, there was other people using his.
And he was relaying, hey, take this number down, tell so-and-so's girlfriend, blah, 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 right?
That's very frequent.
Jump on the phone and, okay, three-way calling comes up, right?
It's happened, yes.
It is entirely possible that there was communication we don't have on any jail calls.
It is it is possible, yes.
It's likely.
It's possible, I don't know. You can,
Are there pictures did you have anybody take pictures of the spider webs showing that all that stuff in the shed wasn't disturbed for a long time?
we've four-cornered some things in the close-ups of the items we've taken. Whether or not we took pictures of spider webs and things, no.
And the only other question I have is, what is the date of the investigative letter that Ms. Jones-Brown showed you involving speaking with Cassie again? I believe a subpoena is referenced, and she adds some information to what she'd already told you about this case.
I think she took that letter back.
Is April 4th sound familiar?
Yes, yes.
Did you write it the day that you talked to her?
I would have to see the letter again. Usually the date of the report and the date could be different, but I don't remember if I wrote it the same day.
Wouldn't have been that far.
No, I would have been within a day or two.
That was of this year, right?
Yes.
That's all I have, Judge.
Any questions from the jury? Okay, Detective, if you'll give us a minute.
Sure.
Attorneys up here, please.
mention that there is confusion in this case, and the confusion lies with Commonwealth's theory. You've heard testimony that our client was originally charged solely as a principal, solely with murder. 13 months later, he was charged along with Gowker as a principal and or as a complicitor. So he stands now either or. Either or. Let me talk about the tampering with physical evidence first, because I think that issue is much easier to resolve. In order to be guilty of tampering with physical evidence, the defendant has to do something with evidence. It couldn't be fake evidence. It's not a crime to dispose of fake evidence. So in other words, to tamper, the Commonwealth has to show the jury beyond reasonable doubt that it was real evidence and not something else that was disposed of, tried to be hidden, or whatever that sort of thing is. So what evidence is there that Joshua Young tampered with physical evidence? We have to go back to the testimony of the two experts. The first expert, Dr. Nichols, testified that he believed, and in his opinion, there was no evidence that the murder was caused in more than one person. And he believed that all the injuries were caused with a metal object, a cylindrical object, that could not have been a baseball bat. Dr. Amy Burles-Beckham testified that she agreed that the injuries on Trey's back, the parallel track lines, could not have been caused by a baseball bat. It had to be something smaller. The injuries, I think that the Commonwealth tried to obtain information with her that there was a different kind of injury to the neck area, and that could have been a baseball bat. With respect to the injuries to the face, Dr. Burles-Beckham testified that originally she thought it was inflicted by a sharp instrument. Then she received information from the detective that a bat was involved. She then changed her opinion to say that it could have been caused by a cylindrical blunt instrument. And then on cross-examination, she insisted that she believed that the bruising underneath Trey's eye was caused by a fist, could have been caused by something like a fist. So there is absolutely no evidence. There's a lot of speculation, but there is no evidence that a bat was in fact used. And when we take it a little bit further, with respect to the little diagram that Cassie drew, she drew a single blood spot on the bat. She was asked to draw what the bat looked like, what the blood looked like. You saw the pictures with blood spattered everywhere, everywhere. Dr. Nichols testified that the weapon would have looked like, would have had droplets of blood all over it. Now that's very convincing evidence. With respect to how the evidence was carried, Cassie said that there was one Kroger bag. She couldn't see the contents of the bag. I think the assumption was there were clothes in there, and the assumption that there were bloody clothes. But I held up the Kroger bag that I had with the article of clothing, and, you know, it's kind of hard to imagine how you could get shoes and a shirt and everything to fit in a bag like that. But nevertheless, she saw a bag of clothes. We don't know where the clothes came from. We don't know if those clothes were bloody. She also said that Joshua carried a bat. The bat was not in a bag. We think that that particular testimony, in light of the two medical doctors that talked about the object that was actually used in this case, is unbelievable. It might be a scintilla of evidence, but this case is so strange, and a lot of the witnesses have credibility problems. There are a lot of stories going back and forth, but there is no direct evidence that those objects were the objects used in the commission of the crime. And therefore, I am asking the court to direct a verdict of not guilty in connection with the tampering charge based on the insufficiency of the evidence. With respect to the murder charge, again, I had mentioned that my client was initially charged as a principal and now as an accomplice. And I would respectfully state that the Commonwealth needs to have a theory of what happened in this case, and perhaps they will let us know. But what does the evidence show in this case as presented? We know from Gowker, who has zero credibility, but the words that were spoken is that he did this alone. So that would make him the principal if the jury would believe that he is the principal. There is absolutely no supporting credible evidence to believe that our client conspired or was solicited or facilitated or did anything in connection with Gowker being the principal. No witness puts him at the scene. No witness other than Cassie ties him with the purported weapon that wasn't even the weapon in this particular case. So there is no evidence that he acted like an accomplice in any way. You're looking at principal and accomplice. I don't think that, this case, with respect to everybody, but there is a lot of garbage out there, and that has been shown with the impeachment, the inconsistent statements, the motivations, and that sort of thing. There is a lot of garbage that has been thrown up on a wall. That does not mean that the jury should be able to sort through all of the garbage and try to put pieces together that might result in a conviction. There has to be some meaningful evidence. So, theory number one, Gowker did it by himself. If Gowker did it by himself, then my client is not guilty. Theory number two, Joshua did it by himself.
Joshua Young?
Yes, Joshua Young did it by himself. And then number three is, let me just talk a little bit more about complicity. That means that the jury would have to believe beyond a reasonable doubt that my client had the intent to promote or facilitate the commission of the offense. So there would have to be evidence of that. We would submit that there is no motive that he had any intention to commit the crime of murder or to facilitate the crime of murder. All of the motive was on Gowker's part, not our client's. Did he solicit, that's the definition of complicity, did he solicit somebody to commit this crime? Clearly, there is no evidence that he solicited. Did he command? There is no evidence that he commanded anybody to commit this crime. Did he engage in a conspiracy? There is no evidence that he engaged in a conspiracy. I guess the only evidence of that, if you want to call it that, is after almost 2 years, Cassie now remembers that when Joshua came up with the bat and the clothing, that Gowker was somehow there. We don't know what time Gowker got there. We don't know what time he left. We don't know what he did. We don't know what he said. We don't know his involvement. I do not believe a conspiracy can be proven by mere presence alone. So to be an accomplice, he has to be a conspirator. And then, along with Gowker, he has to aid. Did he aid Gowker in any way? Did he counsel Gowker in any way?
It's not and, it's or.
I'm just going through the various ones. It's one or the other. Did he counsel? There's no evidence that he counseled Gowker. Did he attempt to aid Gowker? There's no evidence that he attempted to aid Gowker. In the planning of or the commission of events, what evidence is there that it was planned by our client? What evidence is there? I know that there's some, what I would call, dredging up any possible thing that they could come up with. The fact that he somehow missed a rebound and that Gowker said, you know, you got to win, or I don't remember his exact words. I don't even know why that was relevant. I know that that is grasping at straws to try to paint a picture of a situation that does not exist. Also about something about the lights and Joshua trying to sneak up on his dad. I don't know what that's supposed to show. There's a lot of innuendo, there's a lot of inference, there's a lot of character assassination. There's certainly a lot of community outrage about what happened, and that's justifiable. But that outrage should not be cast over onto our client for something that Gowker had done. I know that he's Gowker's son. There's probably people in the community that would like to see him punished because he's Gowker's son. And I know that the court's not concerned about that, but the court is concerned about facts. So there is absolutely no evidence of complicity in this. And Gowker pled guilty to being the principal. When Gowker was in prison, it's Gowker. He said certain things, that it was my demon seed and, you know, I planned it. That's Gowker. There is no credible evidence to show any type of complicity. So we should be given a directed verdict with respect to complicity. I think the only thing that is left then is we have to put Gowker's guilty plea aside. Our client was originally charged with murder. I think that's why the Commonwealth is having problems in this case, because they changed horses in the middle of the stream. They changed their theory based on what some jailhouse snitches said. Looking at the whole case, then, is it reasonable to ask the jury to make a finding? And I would argue, even if the issue as to whether Joshua Young is guilty as a principal. I've already talked to the court about the weapon evidence. Trey was not killed with a baseball bat. If the baseball bat, even if this happened...
You want to continue, you and I disagree over Dr. Burroughs Beckham's testimony. Very clearly, she said she could not rule out a bat. You discount that, but that was her testimony.
She didn't say that it was a bat.
No.
It could have been anything. And does it really make sense that there's going to be two weapons down there? There's no evidence. You know, they could have found some footprint evidence. There could have been anything. There's nothing to suggest two weapons. There's nothing to suggest two defendants. Sure, it could have been anything.
No, but even Dr. Nichols' testimony that you place great stock in, he couldn't say that there weren't two assailants. But he said, he did preface that by saying they'd have to be standing in the same place based upon the pattern of the wound.
The burden of proof lies on the Commonwealth, and anything is possible. There would need to be some scientific evidence to show my client's involvement in this with a bat or whatever. The only evidence is that we know that at least one person did this. There's no evidence to indicate that more than one person did this. So theoretically, I guess it's possible that there could have been a bat in a pipe or a pole or something like that. It's theoretically possible. Anything's theoretically possible. But I think we're going out into the range of pure speculation as to what happened. There is no evidence that two people were down there at all. None. Except the possibility that one expert said, well, he could have been hit with a bat. And the bat that didn't have any blood spatter on it, which it couldn't have been what Cassie is saying it is. This whole case is the result of a maniacal manipulation by a real mastermind. And I think that that's probably, it should be obvious to the court now. So, Your Honor, for all those reasons, with respect to each theory, as we move forward, I would ask the court on all counts to give us a directed verdict of acquittal, because at this point in time, it is clearly unreasonable to submit this case to the jury. Thank you.
Thank you very much. Response from the Commonwealth.
Thank you, Judge. First of all, the Commonwealth bringing a new indictment during the course of a case is not a basis for a DV. The fact that Detective Russ continued to investigate the case until he was able to establish enough probable cause to indict Gowker is not a basis for a directed verdict. Credibility is an issue for the jury to determine, and the entire argument of the defense is based on their opinion of the credibility of the witnesses. Cassie testified to being an eyewitness to the tampering. The jury is entitled to get the case and to assess Cassie's credibility and whether they believe her. That establishes that we have enough evidence to surpass the directed verdict and to take this evidence to the jury. On the murder, Angelique, Jahara, Cassie, John testified to his murder confession. In combination with all the other evidence that we have introduced, we have enough evidence to take this case to the jury and to argue the murder. I have never heard of a directed verdict argument that separates out complicity and principle. Under Kentucky law, it is the same. If you indict under complicity, your burden is to prove that acting alone or in complicity with another, the defendant committed this crime. We have enough evidence in the light most favorable to the Commonwealth to take this to the jury, and a reasonable jury could convict based on this, depending on their assessment of the witnesses.
Thank you. The court, as you all know, has the duty on a motion for a directed verdict to view the evidence in light most favorable to the Commonwealth. In viewing the evidence that's been produced in light most favorable to the Commonwealth has produced sufficient evidence for a jury to return a guilty verdict against the defendant, both on murder and tampering with physical evidence, both under a complicity theory. The motion for directed verdict is denied. Any other motions?
Your Honor asked me to do a synopsis of testimony yesterday. I guess we can take that up now. Together.
Yes. And these are witnesses from the defense. These are witnesses that the defense would like to present that the court has thus far been reluctant to allow you to present.
While he's doing that, Judge, as some of the remainder of the Commonwealth's case was presented yesterday, there were some new witnesses, not many at all, but one of them, and I just wanted to be sure the court was aware that we didn't intend to call these people until, like I said yesterday, as we sat here and communicated by passing notes and lining things up. But Joe Miller, the investigator on this case, may be called. As well
Joe Miller
as,
been sitting here through the entire case?
I did not know that he was in here. Well, if he is, if he's not, then I haven't seen him in here at all. And if he has been in here, then I certainly wouldn't call him. But he knows he should know not to be in here. His testimony.
Unless I've confused him with somebody else, he has been in here.
Okay, well, then we won't call him. What I was gonna follow up with is that he's trying to locate the person that we do need. It's kind of a long
He's
story, but
subpoenaed.
it pertains to the lights at
He's
Liberty.
subpoenaed.
So we do have a witness subpoenaed, but I'm not sure of that individual's name because he just was able to do this yesterday. Also, Sergeant Kevin Blansett from Corrections may be called. And that's it. It's in terms of anybody additional that wasn't on the original list. Who is it? Roderick Burton is the person regarding the lights. I was just told that.
What's his name?
Roderick Burton, right?
Yes, Judge, I think it's R-O-D-R-I-C-K, B-U-R-T-O-N. He's the plant manager at Liberty High School.
Okay. All right, can I see your tender list, please? Okay. So your tender, at the court's request, synopsis of witness testimony that you'd like to present. It includes Allison Miller, Matt Hayes, Susan Stoneburner, Bridget Fraley, and the others that we've mentioned today, with a brief synopsis of what their testimony would be.
Yes, and there are other witnesses, but I do not anticipate
it occurs. If they've successfully deceived him, he wouldn't know.
It's discovered routinely through, in discovery, I just thought that it needed to be addressed, Judge. And again, I just want to note that there are other people that we intend to call, and this isn't the normal way that, the defense puts its case on. I know this became kind of a weird issue, and we're trying to address that issue, but we did provide a list, and we really don't believe there's any controversial witnesses aside from what there's a writing having been submitted to the court right now. But, we have other witnesses. We don't know if we're even going to need very many of them at this point, but I don't want the court to think that we're somehow going to call people that we didn't provide at the beginning of the trial.
Right, and the reason we did this is out of courtesy, because we were talking about the timeline, and I really didn't think that there would be a problem, but in the abundance of caution, I wanted to let the Commonwealth know of an area they might have a problem with. They do have a problem, so that we're not jumping up and down in front of the jury.
Well, you submitted a list. I can't put my hands on it right now. It was a handwritten list of approximately 26 witnesses.
Right.
That was the Commonwealth's list. I submitted a typed list, but there were numerous witnesses, many of whom we do not need to call at this point. We did note at the top of that list that it would be on an as-needed basis, and, for example, several things were acknowledged that I don't need to call anybody to testify about, so a lot of the witnesses involved that kind of testimony.
We've made some strategic decisions, and as the evidence unfolds, ideas about calling people. Like I said, we don't want to just repeat stuff. So we're down to, you've got the 4 witnesses there. We still haven't resolved one other witness that's very short that we may or may not call. I just think it's just we're just talking about 1 or 2 more witnesses. So in addition to those, so our witness list has shrunk. And then not with respect to the other witnesses that we just found out yesterday that we were going to need to present them to contradict testimony that came up that we did not anticipate would come up in the trial.
All right, I think I interrupted the Commonwealth in their response.
I'm sorry?
I think I interrupted your all's response. I don't know that you were done.
Well, basically, the majority of the information in this writing involves either cumulative evidence that's already in, improper character evidence, or improper hearsay. Having other people comment about Josh Young's, feelings about anyone is improper. Having Allison Miller testify that she tried to engage Detective Russ and assist him in the investigation and her offers were not received is improper. First of all, they didn't even ask him about that, so you can't put someone on. I guess if they asked him about it and he denied or there was something to impeach, maybe, but they didn't ask anything about that. And they want to put on improper character and hearsay evidence to support the theory of the case under the idea that supporting the theory of the case makes something relevant and admissible, and it doesn't. There are rules of evidence that we're all supposed to follow, and these witnesses, other than the very limited impeachment from Bridget Fairley, are not proper.
Let me just say there's no character evidence at all. They were allowed to testify to try to show our client's state of mind, the fact that he said he's not blood or something like that. What is that supposed to show? That he wasn't sad at the funeral or that he didn't cry at the funeral? This is the type of evidence we're talking about. We need to rebut that. We can rebut that through those witnesses. Also, Amanda talked about the relationship between Trey and Joshua Young wasn't a good one. We've got another witness that met with them in the house approximately a dozen times, saw them interact when they were together in Gallagher's house, and she'll say they got along great. So I don't think it's fair that the Commonwealth can throw this stuff out there. This innuendo, these lies, basically is what they are, that there was some bad feeling between these good friends. And we want to be able to rebut that, and we can rebut it with witnesses. But we didn't start this not crying, no remorse or whatever. And also, you're talking about kids and they react to grief in different ways, and a lot of that's psychological, and the fact that somebody just sits there stone-faced, what does that mean? I don't know. Maybe somebody doesn't cry, but he cried plenty. We got witnesses that are going to say he cried plenty when this was going on. And we want to introduce that to rebut their inference that he did the murder, and he was a pallbearer, but he was just stone-faced and he wasn't sad at all. So I can't imagine why we couldn't get that in.
608.
Well, what are the defenses that the defendant is asserting in this
He
case?
did not do it. He was not there. He did not know what was going on. He was duped by his father.
Any others?
That's it.
I've got a more thorough list than that. What about the alt perp? Somebody else did it. Mr. Gowker.
I thought that was obvious since Gowker did it.
What about the bad police investigation?
That's a theory of our defense. Why they had, that's, what I'm saying, that's an argument that we will make, that they had tunnel vision, that they got focused, my gosh, Judge, they're down there. They're calling a prosecutor to solve this case, to give somebody that they haven't investigated immunity without really looking into the situation. That's how desperate Commonwealth was to solve this case. That on a word, they're giving somebody immunity on the word of a police officer, and they're doing it over the phone to try to get somebody to talk. Now, I think that that's tunnel vision, and I think that that's not thought out, and I think that demonstrates they jumped to a conclusion. There was a lot of pressure to solve this case, and they came up with somebody. Especially in light of those phone calls you heard. These are not credible people. But they bought into this. They charged our client, and once they got a hold of him, they didn't let him go. And I think that's a fair argument. So our ultimate defense is he did not do it. There are themes that support that. We've got to show that the police, well, we don't have to show anything really, but we want to show that the police investigation was flawed. And I think, based on the testimony, a jury could make that determination. We talked about not doing phone records and not picking up one instrument. There's plenty of fodder out there. And dealing with the type of people they dealt with, they did not even call our witness, our out-of-state witness, our abduction victim. But yet they put forward Jahara, and they didn't even try to see if that was true or not. I think that speaks volumes of the quality of the prosecution in this case, the one-sidedness of this case. They should have at least called the victim to see what really happened during the abduction. They wanted to put somebody on that would say that our client was worse than his father, that wanted to kill her. All this baloney, and I think you understand that it is, and I think the jury does. But we want to be able to argue that to the jury. And we should be able to argue that.
This objection is
Well, you've
not
got
about
the
the
ability to argue it now.
We want to be able to use, I think you asked me in conjunction of, when Allison Miller says she was working very hard on this case, she was our client's mother, essentially, and she deserves a lot of credit. And she saw the police investigation going in the wrong direction, and she tried to interject herself, and she couldn't even get anybody to listen to her. She had all the information about the abuse and everything that else was going on with manipulation, and they turned a deaf ear to her because they had their suspect. They had the case solved. They had probable cause because some person mouthed some words that our client was involved. It was controlled by a criminal mastermind.
Well, I will let you put Allison Miller on for the sole purpose of giving testimony about how Mr. Young and Trey got along together. Period. Nothing else.
Thank you.
Your
Nothing
Honor,
but
may
the-
I ask one clarifying question? Because I prefer knowing these things ahead of time and not being at the bench. I think we all do. If we have an eyewitness to some, like our client's demeanor, they sat 3 rows from him at the funeral and he was crying his eyes out. That's not, we're permitted to put that on, right?
I'll let you put that on.
Okay, just things of that personal knowledge issues. And I understand the Commonwealth's fair warning about opening the door, and I'm acutely aware of that. So
We're not going to have
We
any
don't intend
character
to do
evidence, we're
that.
not going to have any family dynamic evidence. I think that's all impermissible under the decisions in Newkirk, 937 Southwest 2nd, 690, and these are all sexual
Okay.
accommodation abuse cases,
Okay.
but they talk about ultimate issue, and you can't put an expert witness on to give testimony
Right.
about credibility. Martin, 170 Southwest 3rd, 374, and Sanderson, 291 Southwest 3rd, 610. Bridget Fraley was...
Just can I ask you about the fact that Amanda created the impression that Joshua, to Allison Miller, when she did a home visit, told Allison Miller that Joshua was staying there and showed him his room?
Who are we talking about? Joshua.
Yeah.
Joshua,
Remember, this is your rule.
I'm sorry?
Joshua who?
Young.
Young.
I was talking over him.
Showed her what?
She testified that our client only stayed there for 2 days, maybe 1 or 2 days. That is not true. Our client was getting overnight visits, partial visitation, Yacker didn't get total custody until March 24th, I think. She went there, she makes a visit to make sure everything is right.
The bottom line is there was a bedroom.
Mr. Schuler's arguing.
I'm sorry. I didn't mean to
Go ahead.
cut him off, but
Well, you did. Stop doing
I
that.
realize that.
Go ahead.
She goes to make a home visit. She has to look at the house. Where is everybody sleeping? There's a fold-up bed in the room with the tanning bed. Alice, she's told by Amanda that that's Joshua's room.
So what?
She lied.
That's not admissible testimony.
I have her subject to recall, where I could ask her if she told Allison Miller that, and also have Terry Zwicker recall to ask him one question as well, and I've already talked to the Commonwealth about it with respect to Amanda testified that Trey was afraid of the dark, and Terry has no knowledge of Trey being afraid of the dark, and I want to call him for that.
We object.
I think it's all collateral.
Is it okay if I just explain why I don't think it is?
Yes, sir.
The issue is whether if he were afraid of the dark, then there's I guess the jury could believe he left the house by himself and he went somewhere. There's an argument that he wouldn't have gone any place because he was scared of the dark. We think that he wasn't scared of the dark, and we need the jury to know that at least his father believes that he wasn't scared of the dark, which makes it more likely that he would be with somebody when he left the house.
You want to call Terry Zwicker to prove the point that Trey was not afraid of the dark.
Yes, and Amanda said that he was, and that came in.
As did Yacker and as did Young. The purpose of having a witness subject to recall is if something comes up during the course of the trial that they did not have notice about and they want to ask about. They just forgot to ask Terry Zwicker if he had an opinion about whether Trey was afraid of the dark. That was in my opening. They were on notice that there was going to be testimony. It's in discovery. It's in the transcripts. They just forgot. So we object. Well, then they made a bad strategic decision.
I think you have discretion to allow me to call, and I think it's an important issue. And I think the court is aware how convoluted all the testimony is, and even with our social worker and 2 lawyers trying to keep all the facts in this case straight is a Herculean task. We're doing the best that we can do. It's a very difficult case to try. It's difficult to remember everything if you want to do, even if you have notes, because you can't always find what you need, depending on what comes up and what doesn't. So I'm going to ask the court to allow me, in your discretion, to ask them that question.
I will allow the defense to recall Terry Zwicker for one question. Was Trey afraid of the dark? The light testimony from Roderick Burton, I suppose that's germane and relevant. I'll let you put that on. Although I question the relevance of the testimony from Sergeant Blanchett about the the telephone communication jail call testimony. I'm going to let you put that on. I don't see a need to call your investigator, Joe Miller. I know he's trying to, what was it he was going to testify about?
He actually personally sat around in the dark at Liberty looking at the lights. But he was also trying to locate an individual who could testify to the lighting situation.
And you've done that.
And we have
you're
found that
you're
person.
trying to get him subpoenaed.
Oh,
We
yes,
haven't
sir.
subpoenaed.
Yes, sir. So-
All right, so we don't need Joe Miller. I'm not going to permit his testimony, but Burton will be able to testify. You're going to be able to put Fraley on for the limited purpose of perfecting the impeachment of McKenzie.
And while we're doing this, can I just tell you our one other witness that I didn't list that I didn't think we'd have a problem with?
Yes.
And I'm just hoping that, I would ask the court to instruct, I'm just hoping that she doesn't get barraged with phone calls when her name goes out, or, because there's a lot of stuff going on in the community now about this case. There's a lot of people talking to the media. There's a lot of, there's a whole other story out there going on. As a footnote, let me just tell you, I'm really concerned about Mackenzie's testimony, how an 8-year-old girl that makes a story, and then 2 years later she comes in and she says something, she knows the exact date when something happened, and she tells something that she's never told anybody before. I'm real concerned about that. I know she denied talking about it, but where there's smoke, there's fire. There's a lot of that stuff going on. But we want to call Cindy Gunther, and Cindy knows all these people, has known them for years. She was married to Joshua Young's uncle. But the thrust of the situation is what she's going to testify to is that she visited our client at Amanda's house, and she was there about a dozen times. And the times that she was there, that she saw them interact, and it was always friendly friendship. That's all she ever saw. She never saw any negativity between them. She would also testify that after Trey died, she was playing a supportive role and actually spent a lot of time with Amanda and tried to comfort her and all that. And again, Amanda's subject to recall, but she said that Amanda hugged her and said she really couldn't remember anything that had happened because she had passed out. She's also going to testify that she went to the funeral, and Joshua was standing right. He was a pallbearer. She was right next to him.
Joshua who?
Young, I'm sorry.
Thank you.
Gallagher's always Gallagher, so please forgive me.
This was your rule that you created.
My
I'm
rule,
just trying
and
to
I
enforce
admit
it.
to the limitations of my being able to factor in all this information. That he was very sorrowful, sad. He was very tearful. And I think there's one other thing that she's going to testify about as well. Is that it? Those three things, and I think they're all relevant, and we need to get that in to contradict some of this other stuff that has come in to the contrary. We didn't put her on there, but I couldn't imagine she's not going to testify about character or anything. She was there. She was in the house. She's going to testify about what she observed during the time that all this stuff happened.
We would object to everything except her observations of the defendant at the funeral.
I'll let her testify about her observations of Mr. Young at the funeral. No family interaction.
I think that's it. I think that'll be it.
So no Matt Hayes, no Susan Stoneburner. Now, if at some point in time, I think you've preserved your request to put these witnesses on, what they would say. I think you've given an adequate tender at the request of the court. I do not believe that you have to take the next step and put them on by avowal.
May I consult our appellate division and ask them what I need to do?
Certainly. And we have a little bit of time because we're going down for the afternoon. We're going to resume testimony tomorrow morning at 9 a.m. with the defendant's case in chief. Do you have a feel for how long, with the limitations that I've imposed upon you, how long your case in chief will take? You heard me predict to the jury that we may instruct and close on Friday.
Less than a half a day.
I think Friday closings are my preference. I think that's probably, I think certainly we will be done with closings by the end of Friday for sure.
Okay.
We don't have long witnesses.
And I think to be fair, what we've been doing is, well, what we're trying to do is get the clips of evidence that have appeared in the trial. We've ordered the videos from downstairs and over.
We still have a technological issue that the last I heard was that the JAVS people who run our system have not been incredibly helpful in terms of sending somebody to solve this problem with Monday's tape. One of our court administrators was able to download it onto a hard drive and took that hard drive down to audiovisual, and hopefully they're going to be able to pick up the Monday tape and burn copies from that.
What we want to be able to do, and I know the Commonwealth wants to be able to do as well, and I don't want to speak for them, but, and I know somebody's streaming the trial on the internet, but what we need to be able to do is have...
Well, there's a bunch of different media outlets that are doing that.
It's hard for us to... We need an official with the time and everything so we can clip it, the important testimony that we want the jury to see, and it's going to take a little bit of time to do that, to get that together.
So you're anticipating using snippets of trial testimony in your final arguments?
Yes.
And we
Well, you
will-
know that we have to have a snippet hearing. A snippet hearing. Oh, I'm so excited
Is
that I
that
know
what they're-
something that you all don't know.
Actually, do we really
We
need a
do?
snippet hearing if everything that we show has been admitted as evidence? If we put something else in, like something that's not, if it's not testimony, then I think we would need to share it with the court. But if it just says we want to prove X and we have the witness there saying X, I mean, we're happy to show the Commonwealth. We'd rather not, since we have to go first, give them a whole lot of notice on what we're going to say in closing.
Yeah, I would,
but-
as long as it's clips from the testimony itself, I don't think it would be objectionable, and I wouldn't think we needed to show each other.
In other trials that I've had with the Commonwealth, you all have showed clips.
Well, here's my note in my law outline. Morgan versus Scott, 291 Southwest 3rd, 622. 291 Southwest 3rd, 622. A 2009 Kentucky Supreme Court decision. I may be wrong. A plurality of the Kentucky Supreme Court outlined a new recommended procedure for use when counsel wish to place snippets of video deposition testimony. That's different.
And this would be all stuff that's already ruled on and was admissible that we down at the court would say it was improper to show it.
Yeah, as long as it was played during the trial, or is a clip of actual testimony, I would not think it would be objectionable.
Well, it could be objectionable if it is done in a fashion that is misleading or confusing to the jury. So I think that re-looking at this note on Morgan versus Scott, it pertains to videotape deposition testimony. Although I think you could make a good faith argument that the same theories, arguments, cautions apply. I'm going to let you all do that.
I was listening to you.
It's just I don't want it to turn into a regurgitation of what all the trial testimony was. I hope it doesn't make final arguments 4 hours long on each side.
No, I don't expect that.
I think it's just going to be like the key points that we want the jury to remember, maybe 3 or 4 or 5 or something.
I'm fine with that. Commonwealth has no objection to that. Probably going to do the same thing.
Yes, sir. I'm sorry, I just wanted to...
Now, we've had problems with the Commonwealth's technology in terms of being able to play files, video files.
It was, I think it was that primary recording that was at the CEC office. It was of a
Source problem.
lesser quality. Yeah, we had trouble with it at the office as well. But, you know, the audio file from Detective Maroney, there was no trouble. I don't think that we'll have any problem with the official JABS recordings.
Well, and we'll certainly kind of do a dry run again
Right.
that morning. We'll set up sufficiently early, power everything up, and let you all do a little dry run to make sure your technology is meshing with our technology,
Thank you.
So our closing's officially on Friday.
based upon what we know today.
I'm running out of suits, that's why I'm asking.
And assuming there would be, hopefully there'll be an acquittal, but if there were a conviction, I guess it would depend on when the jury would come back, but when would you want to do the sentencing hearing? If there were.
If there's a guilty verdict, depending upon what time they come back, it's more likely than not that a penalty phase would be on Monday, not on Friday. I have a real strong dislike for keeping the jury late, unless we just absolutely positively have to.
And the only reason is, I do have a number of possible, if we need them, sentencing witnesses, and I'd have to get them lined up. And if I knew I didn't have to worry about that on Friday, it would help.
Okay, let's say you don't have to worry about that on Friday. We won't do a penalty phase if necessary until Monday.
Thank you.
Now, what if the jury gets the case, let's say, arguably, by the time you all argue, we instruct and argue, it's going to be lunchtime, earliest possible scenario when they get the case. We'll probably pre-order lunch and have that back there for them. But let's say they deliberate until midnight on Friday night and haven't reached a verdict. Have you all given any thought to whether the jury will be sequestered or whether you'll give consent to the court to let them go home?
We believe they should be sequestered.
If sequestered, will we sequester them for the weekend and not resume deliberations until Monday? Or would we give some thought to whether we could deliberate on Saturday?
I wouldn't want them to have to just spend the weekend.
Yeah,
We
Be
think
in
probably
favor of Saturday.
I would think we should go Saturday.
All right, well, we'll talk about the logistics of that with the sheriff's department in terms of being able to adequately man the building or woman the building to accommodate that.
Staff the building.
Staff the building is a much better term, thank you.
I'm loath to bring this up, and I am attentive to everything the court tells me. But would you mind, again, telling me what Allison Miller is allowed to say, and so I can instruct her exactly so we don't have any screw-ups in front of the jury?
Her observations of how Trey and Mr. Young got along together.
That's it. Thank you.
I believe, Mr. Shore, you all mentioned something yesterday about someone testifying about your client being at school. Is that?
I don't think we're going to present that. I mean,
Has Mr. Young made a decision?
We probably think that that's not going to be really relevant.
Has Mr. Young made a decision yet whether he's going to testify?
We haven't made a final decision. One second.
We haven't made a final decision.
Okay.
It is unlikely, but
Okay.
that's about where we are.
Okay. Anything else we need to take up today before we adjourn?
I think that's it, Judge. Thank you.
All right, we'll
And
see
I
every...
emailed the jury instructions.
Yes, we gave you copies. We made a copy of your email and distributed those.
We did?
It's okay.
We're fine.
So, I guess we have to wait till all the evidence is in, but I've been looking at these, and I would have some specific objections to the language.
And I'll give you an opportunity. I like to have what's called a jury instruction objection conference, where we sit down on the record outside the presence of the jury and talk about the instructions. We can address any instructions the defense would like. but I pretty much will put together my final draft of what I intend to instruct on and get your feedback on the record as to whether it's appropriate, correct.
We could do that maybe tomorrow.
Tomorrow
after the
afternoon.
minutes. Would that be
Right,
okay?
right. That's the time to do that.
Thank you.
All right, thank you all. See you tomorrow at 4:09. Do. Okay. My own worst enemy sometimes are.
We'll come over and see you and then talk about this stuff this afternoon, probably, or I will.
We'll just call you.
You mean like you're in a foot chase, and you're like, come on, here. You're like, I just saw him drop the gun.
Yeah, well, let's cross that proverbial bridge when we get there.
Lisa, can you talk to her for just a second? Probably better for her to come here. I'm gonna work Saturday,
Don't we all?
I'm already scheduled to work Saturday, so
You know, all that overtime that we get?
there's no way have the jury stick around and get nothing for 2 days.
Oh, that'd be awful. That'd be awful.